What he did is he set up a company in the same name, but he set it up in Cyprus, and then he started transferring copyright and other assets, and crucially, the intellectual property for the source code for the app from the English company to the Cypriot company. I'd like to tell you about a case from 2023, and the name of the case, bear with me, is Ntzegkoutanis versus Kimionis. Why is the case interesting? It's because it gives you an indication of when you've got a shareholders dispute, should you issue an unfair prejudice petition or should you issue a derivative claim? Let's get into the story a bit. Giannis Ntzegkoutanis, let's call him Giannis. He put together a cryptocurrency wallet app. Spent lots and lots of time building it up until finally it was finished in 2016. He went into business with his friend Georgios Kimionis. We're going to call them Giannis and Georgios. Giannis and Georgios went into business. They set up a company called Koinomi. They set it up in England. They were both directors. They were both 50% shareholders, and they were going to use this company as a vehicle to exploit the fantastic bit of software that Giannis had put together. That worked for a few years, but then Georgios got better ideas. What he did is he set up a company in the same name, but he set it up in Cyprus, and then he started transferring copyright and other assets, and crucially, the intellectual property for the source code for the app from the English company to the Cypriot company. So that meant, in the end, that Giannis, having done all the work, was left with shares in a company that had no value. So what Giannis did, he brought a court action. And the type of action that he brought was an unfair prejudice petition. Now that is an action by an individual shareholder against another individual shareholder. So the claimant is Giannis personally. Now he asked for three things. He asked for an order that Georgios sell his shares in the English company back to him. Fine. He also asked, though, for compensation from Georgios back to the English company. So not to him personally, but back to the company. And he also asked for a declaration that assets now held in the Cypriot company were in fact being held on trust for the English company. Again, that's in favour of the company. Now the question here is, can you bring an unfair prejudice petition when what you're asking for is remedies for yourself? That's fine, but more controversially, on behalf of a company. Now usually, if you're asking for a remedy on behalf of a company, you need to bring a derivative action. That's where you, as a shareholder, ask the court to act on behalf of the company and then seek remedies for the company that way. Giannis went to the court with an unfair prejudice petition asking for all those three things. The court agreed with Georgios and didn't agree with Giannis, and it said, well, under an unfair prejudice petition, you can have the order about sale of shares, or you can pursue the order about sale of shares, because that's for you personally, but you can't have the other two elements that you want because they're for the company. And so those two elements of the case were struck out. So Giannis was still free to pursue his claim for an order for sale of shares, and he could go back and bring the other two elements of his claim afresh as derivative actions. But he didn't want to do that, so he went to the Court of Appeal, and the Court of Appeal overturned the High Court decision. They said that actually, because unfair prejudice petitions have a very wide discretion, that all three elements that Giannis wanted could be allowed under his proceedings. Now, that's contrary to a preceding Hong Kong case called the Chime case, and is really a new position about the kind of cases that you can bring under an unfair prejudice petition. So you can bring under an unfair prejudice petition an action for yourself personally and an action for a company if the two are linked. I think you can't bring an unfair prejudice petition just for remedies for a company. Hope that was clear. Hope that was helpful. Here's the rub. If you're a shareholder and you're looking for a remedy yourself, you can bring an unfair prejudice petition. You may be able to put in some elements for a company as well. But if your claim is just about getting redress for a company, you still need to bring a derivative claim. I hope that was helpful. If you have any questions about shareholder disputes, unfair prejudice petitions or derivative actions, please get in touch. You can book a 30-minute meeting with me by going onto the website and clicking the book a meeting button, or you can give us a call or drop us an email. All of those details are on the website. If you'd like to ask a question, please leave it in the space below under this video, or any comments that you have will be most welcome. We'd love to hear from you.